good afternoon and good morning to everyone joining from different parts of the world. And a very, very warm welcome to the monthly JSW Center for the Future of Law seminar series, where we engage with cutting-edge scholarship by leading thinkers in law and governance. We are delighted to host Professor Rebecca Williams, who is a professor of public law and criminal law at the University of Oxford and a fellow at Pembroke College. She co-runs one of the UK's first interdisciplinary courses in law and computer science for graduate students, which I also had the pleasure to be a part of. And her research increasingly focuses on the challenges and opportunities posed by new technologies. Her work has been cited by various courts, including the UK Supreme Court and the European Court of Justice. She is currently co-investigator on major UK-funded projects exploring accountability and intelligent legal systems. So today, Professor Williams will share insights from her paper, which is titled The HP Source Problem, Social Scoring and Law's Response, where she looks at aspects of algorithmic fairness, including the use of data from one context to reach decisions in another. Following her presentation, Ms. Shriya Sridhar will offer her comments on the paper, after which we will open the floor for questions and discussions. Professor Williams, thank you for joining us today. It is a real pleasure to have you with us, and the floor is yours.
Thank you so much, Isha. Thank you very much for the invitation and the opportunity to share my work with you. And it was a pleasure having you and Johnson, who I saw a minute ago on the course. So lovely to reconnect with you. So yes, as you mentioned, I'm going to talk about a thing which I call the HP source problem, which is actually what my co-convener from the Oxford course, Tom Mellum, and I call it, which is this situation which has arisen particularly with the use of big data, about the use of sort of out of context data. So you might well be thinking, well, why has she got a picture of HP source on the screen and what's all of this about? And the answer is that in 2016, following the Brexit vote, a marketing company used YouGov profile data to establish what were the top 10 brands favoured by Brexiters on the one hand and Remainers on the other. And what they found was that you could predict which somebody would have voted based on lots of things, including their grocery purchases. And among other things, the study established that this purchase of HP sauce, which the sauce people put on their fries, their chips in the UK a lot, that if you're the sort of person who buys this sauce, you're also highly correlated with having voted to leave the EU, with being a Brexiter. So obviously I can't think of a sort of legal reason why you would be allowed to or want to predict. But if we were saying, for example, all right, let's build a system to predict whether somebody was a Brexiter or a Remainer, would and should we be allowed to use your grocery purchases to make that decision? And of course, it might not be something like that. It might be, will you be a good employee? Are you a good insurance risk? Should we give you a university place? These kinds of decisions. Would and should we be allowed to use grocery purchase to make that kind of decision? And of course, this is not the only example. So even before this, a study by Cambridge University had discovered that a wide variety of people's personal attributes, so things like sexual orientation and intelligence, could be automatically and accurately inferred just using what they'd liked on Facebook. So they could tell you an awful lot about a person just from the things that they'd clicked like to on Facebook. And while there's been a lot of attention given to sort of algorithmic fairness in terms of bias and discrimination against particular protected groups, actually that's not the only aspect of algorithmic fairness in decision making. And really, I think relatively little attention has been given to this question of the potential unfairness that might arise to, as it says, using data from one context to reach decisions in a completely different context. Now, the danger is that we do have a bit of a tendency with technology to think, well, if technology is presenting us with a challenge, that's got to be a new challenge. We need a whole raft of new law. This is something we've never seen before. And actually, that's not necessarily the case. So actuaries, even in a pre-digital world, used to undertake risk predictions using data from broader context. They'd look at things like, whether a person smoked or, this kind of thing, or, gender and so on, when they were allowed to do that for predicting driving insurance and so on. And that and human decision making more generally actually are not so different in kind. So humans do process data from their five senses based on sort of learned inference. That's why optical illusions work. We draw the inferences that would normally apply, and then we get caught out, and it's puzzling. So I'm sure you've seen this optical illusion before. And actually, if you were to cut them out on a piece of paper, the two squares with dots on them are in fact the same colour. But your eye doesn't see them like that because your eye corrects for the fact that the cylinder looks like it's casting a shadow on the lower square. So it says, well, I know that square looks darker, but it must actually be lighter. So I'll see it as lighter, and that it looks lighter than the other square. But actually they're not. And so it's your brain tricking you by predicting from the data that it's had in the past that things in shadow are actually lighter than they appear in the shadow. It's extrapolating from that prediction, from its past data, to make a decision going forwards. So what that tells us is that it shows that actually even humans reason in quite a sort of statistical, predictive way quite often. So we'd be wrong to think that the whole essence of the HP source problem, the whole idea of extrapolating from data, is a brand new one that we've never seen before. We've absolutely seen it before. But what is different is that when you have these systems which can use huge quantities of data, they can actually do that in a much more rapid, much more expansive scale than we've ever seen before. So while we might have had sort of individual smaller instances, we can now absolutely industrialize the size of those inferences and the level at which they can be produced using these systems. And so it's that size problem that's really the different thing, not that it's a completely new problem altogether. So because it's now an increasingly sort of big problem and people are more aware of it, because it's more possible and more possible to do at scale, various different systems across the world have started to respond to this. And they've taken quite different approaches. So China, on the one hand, actually promotes a social credit system because there was a sort of perceived crisis of trust, and it was thought to be a kind of block on the economy, that people were not able to trade with each other because there wasn't the same kind of trust in the person that you might be trading with. And so social scoring was sort of seen as a potential means of remedying that. If you know a bit more about that person, you know whether they're a good risk, that if they say they'll deliver, I don't know, building materials to your building site, that they'll probably deliver on that, and you can trust them and you can send them your money. So it was a means of sort of enhancing that commercial trust between contracting parties. And so they're quite permissive of this kind of social scoring. And social credit blacklisting, on the other hand, if you get a bad score by these systems in China, that can trigger measures like, for example, not being allowed to buy high-speed rail or plane tickets, or certain private schools that you're not allowed to send your children to because you've got a bad score on this sort of social scoring approach. The US, we probably have to put on a quite sort of extreme end of the scale as well now, following the abolition of the 2023 Biden executive order on the safe, secure and trustworthy development and use of AI. So the US had been moving in a more kind of almost European regulatory direction, thinking about the potential harms of algorithmic unfairness and so on. But the brakes have very much been taken off by the Trump administration, abolishing that Biden order and sort of putting in place orders to try to enhance the commercial dominance of the US really as a marketplace for AI. So there's some control in the US via things like the US Fair Credit Reporting Act, and individual states are increasingly legislating to regulate algorithmic decision making. But at sort of federal level, at least, the US is still pretty permissive. In the UK, the only legal constraints on this kind of thing come from the UK GDPR, which has now also been amended by the Data Use and Access Act, which does have some constraints on automatic decision making, but not particularly in relation to what you're allowed to take into account, just in terms of things like making it clear that you must know what's being taken into account, you must know the meaningful information about the logic involved, and you must have, in certain instances, a right of appeal to a human decision maker. And I'll say a little bit more about that in a minute. If you're a public authority in the UK, there's a bit more constraint. So in public law, we have cases like Cromer Ring Mill and the Tesco Stores case, which say that public authority decision makers can only use relevant characteristics and must take all relevant characteristics into account. So you're not allowed to use something that's irrelevant, and you're not allowed to ignore something which is relevant. So if you're a public law decision maker in the UK, there is a bit more constraint on this, but not so much if you're a private entity. So it's really the EU which has gone the furthest in regulating this sort of social scoring in the form, as we know, of the AI Act. So There are lots of forms of things like biometric categorization and so on that the AI Act also regulates, and I'm not going to go into all of those at the moment, but just to pick out one of its sort of biggest provision on this topic really is Article 5(1)(c). And what this prohibits is detrimental or unfavourable treatment of certain natural persons or groups in social contexts that are unrelated to the contexts in which the data was originally generated or collected, or detrimental or unfavourable treatment of natural persons or groups that is unjustified or disproportionate to their social behaviour or its gravity. Now, the EU is often known, as I just sort of put it on the previous slide, as being the system which has gone the furthest and been the most regulatory and been the most interventionist. But very often this is how it's done it, is by putting in place something, but actually it's not 100% clear what that thing covers in practice. So if you start trying to sort of actually think, well, what facts does that apply to and what facts does it not apply to, then it's actually much more difficult to see what the EU is regulated. We know it's done something, but what exactly it's done is a lot trickier to see. So for a really good sort of case study on would this trigger Article 5 or would it not, Cornerstone On Demand is an employment platform, and you can sort of take online tests to qualify you to apply for certain jobs, or for the platform to suggest you for certain jobs and so on. And what they'd established was that people who were taking its online tests on non-default browsers, so things like Firefox or Chrome, which you have to install yourself, not the one that the system automatically gives you, those people who'd applied on those non-default browsers ended up staying in their jobs 15% longer than people who'd used something standard like Safari or Internet Explorer that came with the machine. And those people not only stayed in their jobs longer, but were found to perform actually better doing the jobs that they'd been given. So that's a great example. Is that unrelated and unjustified and disproportionate, and therefore caught by the Article 5? Would the Article 5 of the EU AI Act say, no, that's unrelated, unjustified, disproportionate data, you can't use their web browser to make employment decisions, it's caught by that provision? Or would you say, well, actually, and this is what the CEO of Cornerstone said, well, come on, if you think about it, if you're the sort of person who has thought about what web browser you're going to use and bothered to install a new web browser, you're probably quite a smart person who thinks carefully about what you're going to do. You're not going to apply for jobs that you don't want. You're going to think quite carefully about selecting your employer as well. So, of course, you're going to stay there longer and do better because you're just a more thinking sort of person who's put more effort into the whole business. So then that's not unrelated and unjustified. That's a perfectly sensible signal that you're sending about what sort of person you are. If that's the case, then under the Act, it only becomes a high-risk AI system under Annex 3(4) on worker recruitment, and it's not prohibited, it's just subject to constraints like things like record keeping. So even where we do have legislation like the AI Act, it's actually not obvious how and when it applies. You could absolutely argue both sides of the Cornerstone case, and there's no obvious answer that one of them is right and one of them is wrong. And part of that, I think, is because the Act wanted to put something in place but wasn't really clear what exactly it was that it was trying to target. We know that there's a problem. We know that we wouldn't want unfair uses of people's data in the wrong context, but we don't know what unfair means exactly, and therefore we're not exactly sure how we want to fix it. And of course, the AI Act doesn't apply everywhere either, so there's gaps elsewhere as well that might need filling. So what I think we need, therefore, is a new legal framework that sort of governs this whole issue of what I call out-of-context data use. And the paper which I've sort of sent that she is very kindly going to comment on for me, that goes through sort of looking at what this whole framework might look like. Now, I'm not going to take you through the whole framework now for reasons of time, but what I'm going to sort of pick out are a few of the key rules that I think should be in place in this framework to do a sort of more specific job, if you like, than provisions like Article 5 are currently doing. Now, I should say that before I set off in describing the framework to you, I'm going to make a series of assumptions. So the first one is I'm going to assume, as the AI Act itself assumes, that we do actually know what were the factors that went into the decision. And obviously there's a whole separate set of papers on explainable AI and the extent to which we can know that a particular factor is going into a decision. I'm going to sort of take that as read and assume that this is an explainable situation within the boundaries of what the GDPR and the AI Act require on that kind of front. But that's a whole sort of separate topic for another day. Another topic for another day, which again I'm not going to go into, is to assume that the thing we're trying to predict for is a good thing to predict for. So there is a whole separate set of conversations to have about, for example, if you're doing university admissions, what are you selecting for? Are you selecting for performance on course? Should you be selecting for a varied cohort of people? Lots of questions you can have about that. So I'm assuming that we've chosen that target variable, and it's one that it's okay to try to predict for, to try to select for. And as I say, we can have a separate conversation about how we choose that target variable, which is a whole separate issue itself. And the third thing I'm going to assume is that we are actually trying to predict accuracy. We are trying to sort of make the most accurate decisions that we can. And there are times where we might not want to predict accuracy, where we might be happy with a less accurate decision for some other policy reasons. So those cases, if they apply, then that's outside the scope of what I'm talking about. I'm assuming we've got a chosen target variable, we know what factors are being used to predict that target variable, and we're trying to predict that target variable as accurately as possible. And so that's the sort of parameters of what I'm about to say, is assuming all of those things to be the case. So what do I mean when I talk about accuracy? Well, Pembroke is very fond of telling everybody that one of our famous law alumni is Sir William Blackstone. So there he is. I can't do a talk from Pembroke if you don't mention Blackstone. So I've done it now. And as I'm sure you know, what Blackstone said is that it's better that 10 guilty people go free than one innocent person be convicted. Well, if we update Blackstone to the age of AI, what he's really saying is that I'd rather have 10 false negatives than one false positive. That's how a CS, a computer scientist, would say what Blackstone said. But with apologies to Blackstone, I actually want to say that as part of our framework and pursuing accuracy, when I'm talking about let's try to be as accurate as possible, I actually mean let's think about both. Let's think about our false positives and our false negatives, and how exactly we strike the balance between them. He had good reasons for saying what he was saying in the criminal context, but there might be other contexts where we are more worried perhaps about a false negative than we are about a false positive. So for example, disease detection, we might be more bothered about false negatives than false positives. So we need to think about that on a case-by-case basis, but that's what I'm talking about by accuracy, is how many of each of those do we have and what are we aiming at. And when we think about why we might get those false positives and those false negatives, there are two reasons in particular that we need to be aware of, and they are known as overfitting and drift. So overfitting arises where you have a factor which is predictive and works well within a given data set. So you test it and you go, yes, it's predicting all the cats and it's rejecting all the dogs. That's great. It looks like it's working really well. But it doesn't work outside that data set because it's too closely fitted. It's overfitted to that particular data set and won't extrapolate to other ones. The most infamous example of this probably didn't actually happen. It's often cited, but nobody can find the original source of it, which is a story about an image classifier which was trained on a set of pictures of tanks. And it was supposed to learn to detect tanks, in an environment, in a military context. And what it actually was learning to do was detect the clouds behind the tanks, because all the pictures of tanks had been taken on the same day with the same weather. So it had learned the weather, and then if it saw clouds, it said tanks, and if it didn't, it didn't. And then obviously that doesn't work to a whole different data set where the weather was different in the tank pictures. So that one probably didn't happen, but there are examples which definitely did, and this is the Caruana paper and the Nala paper. So these were systems which learned, for example, that patients who had asthma had a lower chance of developing pneumonia. And of course the reason for that is because the asthma patients also got hospitalized and more intensive treatment. And another system which learned to look for rulers in medical images rather than looking for the cancerous lesions next to the rulers. It was going, yes, this is a cancer one because it's got a ruler in it. No, this is not because it hasn't. And of course, then you take it to another set of pictures which don't have rulers for either case, and it can't detect anything. So in those two cases, what's happened is that there's a confounding factor which causes the predictiveness, rulers, hospitalization, clouds, which is not the thing that you're trying to predict for. So you're not looking for rulers or hospitalization or clouds. You're trying to predict for, will this person develop pneumonia? Has this person got a cancerous tumor? Can you see a tank in the background? And that's not what the system has learned to predict for, because it's learned to predict for a confounding factor instead. And so, of course, that means it's not going to work. So that would be a sort of example of a factor we wouldn't want a system to take into account, because it's a confounding factor and it's not the thing that we're really looking at. So we'd want to knock those out. The second problem I mentioned is drift, which is what happens where something is accurate at one time, but then ceases to be accurate over time. And that's very likely to happen if you've only got a correlation between two things. So that I mentioned the Cambridge University study at the beginning that spotted all sorts of things and could predict things like intelligence and sexuality and so on from what people had liked. Well, one of the things that they found was that if you like curly fries, you're more likely to be intelligent. And probably the reason for that, which is clearly going to be spurious, is because, I mean, curly fries are nice, right? But if you have friends who went to the same sort of academic institutions you did, and those are selective elite academic institutions, your friends are probably people you made at those elite academic institutions. So you've got a bunch of well-qualified people, probably that's your proxy for intelligence. And if somebody posts a picture of curly fries, they're all going to say, yes, I like that because curly fries are nice. So why would you not? So actually what you've got is a group of people who happen to know each other from elite academic institutions, all saying they like curly fries because people do. It's not that there is any correlation between the two. It's just this sort of setup of a kind of network effect, a sort of flurry of network effect, which is just giving you a result at one point in time. It's not going to extrapolate to anybody else. I can't start using it for university admissions to Oxford. You know, it's not really a predictive factor at all. It's just the result of a sort of particular flurry of network activity at one time. So we want to watch for that as well. If something looks like it's predictive of our outcome and it looks like it's being accurate, let's think about, will it continue to be accurate, or is this something which is going to fall off and stop being predictive over time, and we're going to see drift? So that, again, we probably don't want to take into account factors where we think that there's no sort of inherent connection and it's just one of these sort of weird coincidence correlations. So we could go to the opposite end of the scale and say, not just let's knock out those two, but let's go the whole hog and say, let's have a rule that you can only use a factor to make a prediction and make a decision if it's a causal factor, if it actually plays a causal role in producing the thing you're trying to predict for. And Solon, Barocus and co have an open access book on fairness in machine learning, and that's what they say. They say we should just be using causal factors. We shouldn't use a factor that's not causal to make a predictive decision in this way. I personally wouldn't go quite as far as that. I do think that causal factors are ideal. If you're causative of the target variable, you're also going to be accurately predictive of it. So that for sure is the kind of golden ideal that we can all aim at. But it's also worth remembering that very often the discovery of a causal mechanism lags predictiveness. So, for example, epidemiologists could see that smoking must be causing lung cancer long before they knew that there was an underlying causal mechanism. They could just see a very strong correlation. People who do this tend to get that. So we very often, particularly in medicine, are in that kind of context where we think something must be causing something, but we don't know for sure that it is. And so if we were going to say, well, you can only use it if it's definitely causal, we would knock out those cases. And that seems to me potentially problematic. And what that also shows is that the other thing we're saying, oh, you need causation, is, well, it's not really a binary concept. So again, you might be able to say with 100% accuracy, if you carry this gene, you will develop this condition. But we don't know exactly necessarily why that actually is or what the causal mechanism is. So it's not like we have a sort of binary, is it causal, is it not? We think, well, it kind of looks very strongly like it probably is, but, you know, we can't say for sure one way or the other. And actually, even if we're fairly confident that a particular factor isn't causative at all, we might still have good reasons to use it. And a really famous example here is that ice cream purchase is correlated with increased drownings. Now, you can be fairly sure there's no causal link there. It's not that eating ice cream is causing people to drown. But obviously, what's really happening is both things are going up when it gets hot. People swim in dangerous waters to cool off. People eat ice cream. Both things caused by a third thing, which is being hot. But it's the ice cream consumption that you can see. Well, in that case, if that's something that you can see and it's an easy proxy to measure, then there might be benefits to using that. If you know ice cream consumption's gone up, deploy more lifeguards, that cuts drowning. That's quite a useful set of things to know. Even if the ice cream isn't causing the drowning, it's still a useful trigger to you taking some action to deploy lifeguards, which overall is a sensible and good thing to do. Another example is that flu internet searches for flu remedy or what are the symptoms of flu, all of those sorts of searches spike before a flu epidemic. Well, it might be a lot easier to measure searches on the internet than it is to measure the circulating levels of flu virus in a population. So if you deploy your medical resources based on there's been a flurry of flu searches, I'm a bit worried. Again, that's not necessarily a wrong thing to do. That might be a sensible way of deploying your resources and a perfectly sensible thing, even though the flu searches are not causing the flu, they're just a sort of symptom of it. So, of course, implicit in that that point that I've just made is that it depends what you're predicting for and why. What are you using your prediction for? And in both the ice cream example and the flu searching example, what you'd be doing is using the data at an aggregate level to deploy lifeguards or to deploy healthcare resources. You're not talking necessarily about a specific decision in relation to an individual. Where you are, I'll come on to what we should do about those in a minute, where we're talking about very specific individual decisions. So the first sort of set of rules I think that we need for our framework to put in place is that we do need accuracy, but I don't think we necessarily need causation. So the factor that we use must be accurate. It must not be spurious like the curly fries or the tanks. It doesn't, I think, necessarily have to be causal, but we don't want overfitting like the tanks and the rulers. We don't want confounding variables, and we have to check whether it's going to remain predictive over time. And if we think it's not and it's going to drift, then we shouldn't be using it. And then after that, we would like causal factors, but we don't have to have them. And what we need to think about is what's the trade-off? What are the benefits of using a non-causal factor like the ice cream and the flu searches? What are the disbenefits of doing that? Do we have to say it does need to be causal in this context, but we don't have to say that necessarily, I wouldn't say, and I would disagree with Barocas and co for on that particular point. So we're not going to take into account factors which are not accurately predictive or are what Frank Schauer calls spurious. But what if a factor is non-spurious at an aggregate level? So on average across a population, it's a good predictor and it's accurate, but it doesn't work on an individual level for one particular person. So for example, it's true that smokers tend to have worse health outcomes, but we almost all of us know somebody like my granddad who smoked well into his 80s, seemed to suffer no harm from it whatsoever. Probably in the long run, we will discover that those people have some sort of genetic immunity to the effect of smoking. Some people are particularly susceptible, some people are particularly not susceptible. So the problem here is not that it's wrong to use the aggregate generalization as a whole, but what we then need is a legal right to say, yes, but not in my case. So yes, it's fine to use that as an aggregate predictor for general prediction across the population, general setting of insurance levels or whatever it might be. But you have to have the right as an individual to say, yes, I know for most people, but not for me. I'm different. I'm an edge case. I don't fit within that general aggregate rule. And to some extent, I think this is what things like Article 22 of the GDPR are trying to do. That provision is famous for giving people what's often called a right to a human in the loop. And there's lots of other provisions across the globe that have similar, right to a human decision maker, right to a human in the loop. But I think that's not quite what you want for two reasons. First of all, you don't necessarily want a human. In fact, if you get a biased, inaccurate human, they're actually going to make it worse, not better. So I don't think insisting on having a human is necessarily the way forward. And secondly, in Article 22's case, what it gives you is the right to human intervention. But I think you need more than that. I think you need a right to actual micro level correction or individuation of a decision to make it accurate about you. So a smoker charged more for health insurance ought to be able to say, yes, but I have this genetic immunity, and so I can have that corrected, please. Don't just intervene and don't just give me a human, actually give me a correction of that aggregate level decision. So in my case, I really like HP source, but I did not vote for Brexit. So I would be able to say, well, look, I'm an edge case. I don't fit your aggregate prediction. And so whatever it is you're predicting, I need to be treated differently from that. So this right to individuation, I think, is what we really need to sort of allow us to use more factors at an aggregate level, but then not at an individual level. So that's sort of the basis of my argument in favour of what our framework should roughly look like, and say there's more in the paper. What about arguments against it? So is it going to cost more and be much less efficient to do this sort of level of individuation and to be really careful about being predictively accurate? Well, I think let's remember that the whole point of using machines is that they are complex and rapid and able to do a lot of things that humans aren't. So making them more complex to make them more predictive, I don't think is necessarily a bad thing. And in fact, the decision maker can benefit too. If they want to predict for this variable and we're helping them do that better, then I think that's probably okay. What about people who game the system? So if you know what the parameters are, you can sort of bring yourself within them and therefore try to game the system. So, you wear a Fitbit and whatever. And there's an example in one of the papers, somebody says, you could put your Fitbit on your dog and then you'd get lower health insurance because it looked like you were moving all the time. What about that? Well, my colleague Ignacio Cavone and his colleague Catherine Strandberg, they've pointed out that you only can game features which are non-causal. So actually what we can do is we can factor that back into our conversation about, is it okay to use a non-causal factor in this instance? And sometimes it will be and sometimes it won't be, and that's a reason why, why we'd have to sort of think carefully about it. So we can just wrap the question about gaming back into the conversation about, does it have to be causal? Maybe not. We do, I think, have to think about odd incentives or other policy concerns. So just to give you 3 examples, one of them is that supposedly you are a better insurance risk if you have a dog than if you have a cat. But we wouldn't want to tell people that or make that a factor if we thought it was going to distort the pet population across the country. If we thought everybody was going to go out and buy dogs because it would be cheaper on their insurance or whatever it might be, that would be problematic. And we need to think about what incentives are we creating by using a factor. So we don't want to distort the nation's pet population. We also need to think if a predictive factor is a protected characteristic, something for which people have been discriminated against anyway, then we would want to think about that. But of course, that might be different if we were thinking of allocating a benefit, not a burden. And the other context, the other sort of policy reason for cutting down on the factors we can look at is, for example, we might not want to individuate to pool insurance risk. That's the whole point of insurance, is that you pool risk rather than individuating it to particular people. So you might well say, well, you're not allowed to look at these factors because that avoids the pooling of insurance risk. And another example from the US is the Ban the Box campaign to not put a box on job application forms that says, do you have a criminal conviction or not? It might be predictive of I don't know, less good employment. I don't know if it is, but even if it were, you might not want to say that because you do want people to have the chance to be reintegrated into society. So there might be policy reasons why you don't want to pursue accuracy, but again, that goes back to what I said at the outset. So just to conclude then, I think we need a new framework. I think we can use factors if they're accurate or non-spurious, but we need to watch out for overfitting and drift and our false positives and negatives. I don't think we need to tie ourselves to causal factors, but we need to think about it in each case. What's the cost of finding the causal one? How easy it is to find a causal one instead? What's our purpose here? How gameable is it if we don't use a causal factor? We just need to have a conversation each time. I do think we need a legal right to individuation of an aggregate prediction, and that's what I think Article 22 is trying to do, but doesn't quite get there. And I think we sometimes might want to constrain our pursuit of accuracy for various policy reasons and avoiding unwanted incentives, like I was just talking about. So that's it, really. Thank you very much for listening. And yes, I'm very, very keen to hear all of your questions.
Thank you so much, Professor Williams. That was absolutely fascinating. And I would now like to invite, before we have questions, I would like to invite Ms. Shreya Sridhar to offer her comments on the paper. Just by way of introduction, Shreya is a fellow at Shiv Nadar University School of Law, Chennai, where she assists with teaching and curriculum. She also holds an LLM from the University of Edinburgh and is a research fellow at the Pranava Institute, and her research focuses on AI regulation, data protection, privacy, and human and AI interaction. So, Shreya, the floor is yours.
Wonderful. Thanks so much, Isha, and thank you so much, Professor Williams, for that. It was really, really fascinating presentation. For a long time, I have been really, really fascinated by this topic of inferences. Right. So within the area of data protection, how is it we come at inferences? How is it we regulate inferences? So this is a really interesting take on the topic, which I had personally not come across before at all. So it was really great for me to engage with it. So yeah, I think Isha, just please alert me whenever I run out of time, because I feel like I could go on and on about it, and I risk kind of going off on a tangent there. But it was so wonderful to be able to read this paper and see all these ideas that Professor Williams presented in a much more detailed way. Of course, due to paucity of time, I'm also not going to go into an exercise of repetition. The paper is incredibly interesting. I'm really in agreement with the core premise that we actually need to focus on how predictive decisions are arrived at versus only the fact that they are automated. The problem with them is not that they are automated. The problem is that we are making predictions. So we need to actually get at the root of the problem. And from a more like broader philosophical or ideological perspective, I definitely, I'm aligned there, right? Because when we chase this kind of automation as a niche, we are ignoring the very real human decisions behind the technology that is being made. So from that perspective, it was really fascinating to go through Professor Williams' recommendations for this legal framework, because it's very, very right to say that the current legal frameworks are lacking, right? Specifically, we have seen, and I think there's pretty much now global scholarly consensus that data protection regimes are falling short of the outcomes of machine learning algorithms. And what I think even Lillian Edwards and Michael Veal call the transparency fallacy in their paper on why the right to explanation isn't really the remedy that we're looking for, right? So I think that this framework would actually go one step towards kind of addressing that transparency fallacy, which is rather than inundate users with explain. Because even if we were to assume in a perfect world that these machines were explainable and that we are able to, predict with accuracy and we're able to explain it, it still doesn't solve the fact that there's a very large information asymmetry between users and the companies or the entities who are making these predictions. So I think that this framework really sort of lends itself towards unpacking how those predictive decisions are made and addressing the very real problem that fairness is not automatically increased by human in the loop. And I'm very happy to read that, because it's something that I think like if I think the solution for everything now has become human in the loop very often. And it's not a real catch-all solution as much as we would like to think that it is. Right. So these are sort of my initial reflections on the paper that, when I read it. And really what I've just kind of listed down some of the questions that I'm left with. And I don't even necessarily have the answers to these questions, but these are just thoughts and sort of ideas for where, if possible, we can take this legal framework even further that I was left with after reading the paper. So firstly, I'm curious to understand the shape that this framework would take. Like while we have these factors and the different types of predictive factors, when we can trade off between transparency and accuracy, when we can kind of not incentivize for gaming, when we can allow for a prediction that is predictive at an aggregate level, but not at an individual level, and we come at that right of individuation, and several other recommendations that have been made. I am curious to see how we conceptualize that from a legal perspective, because, and why I bring this up is a very interesting paper. I think it's also cited in Professor Williams' paper, which is Professor Sandra Wachter's paper on why right to explanation doesn't in fact exist in the GDPR at all, right? And I think that what they raise in that paper, Professor Wachter and her co-authors, are talking about, instead of how do we interpret Article 22? Do we interpret it as a prohibition or do we interpret it as a right? And if we interpret it as a prohibition, it's actually more friendly to user protection than if we interpret it as a right, which then also puts an additional burden and onus on the users. So I am just curious to know more about how, while we have now this framework, which is very, very useful, how do we operationalize it from the perspective of regulation, and how would, in practicality, how would a user go about exercising that right? And if it is a right, do we then run the risk of running into similar problems that we have in the traditional frameworks that we are critiquing? And then how do we solve for those? The second is, while I'm in so this is my first point. The second point is, while I'm definitely, I am in agreement, as I said right at the beginning, that separating the process of automation and human decision making hardly makes sense, because these machines don't magically act on their own. But what I'm particularly interested in my research, and particularly because I do a lot of work on natural language processing and regulation by design, and I do a lot of work on companion AI also, is sort of the midway between, so that we have automation, we have human decision making, and there are some incentives that happen in between that. So there are choices, there are economic incentives, there are design choices, there are ideologies that go, and I think you can sort of bucket this into, a broader idea of socio-technical lens of analysis of these technologies, right? So the socio-technical effect, when these human decisions are encoded into machines, I think that is a third area in which we might be able to look into, right? So while of course I agree that we should be looking at the process of predictive decision making, I am also interested in that stage in the middle where the human process gets translated into automation, into an algorithm. What are the incentives in between there, and then how do we tackle for those in regulation? And that might look at a little bit of a broader or more macro perspective of what are the incentives going behind these algorithms and what are the intentions behind them. So sort of, I think the term in scholarship is the socio-technical assemblage, right? So that is what I would be interested to look at as well. Right. The third thing that I would talk about is that um, while the factors that we've listed out, and I think they're very neat for anybody looking to sort of get a gist of it in the conclusion of the paper, Professor Williams has very helpfully listed out all of the different components of predictive decision making that should go into this legal framework, and when we should go in favor of that predictive decision making, when we should not, when we should let, for example, the protection of protected characteristics that should trump any sort of accuracy justification or non-accuracy based justification. One thing I would add to that, I'm curious if we could add to that, is whether legal frameworks can at all weigh in on the normative value of what is a good prediction. Right? So rather than just the factors that went into the prediction, uh, because we can make good predictions as long as nothing else changes, right? All things being equal, like ceteris paribus. And that works great for many different types of predictions in history. But typically, we've seen over several decades of computer decision making that it has been very difficult to predict social phenomena using computers. So I'm very particularly interested in this idea of, is the pursuit of predicting social phenomena a good thing? Is there a normative value to predicting social phenomena when there are, in fact, many sources to say we simply can't do it? We simply have to be comfortable with an inherent level of unpredictability. How much ever we try, we are not going to be able to predict social phenomena over time, right? So I'm just wondering if a legal framework on predictive decision making should account for that normative value of the predictions. And secondly, as a kind of corollary to that, when we're predicting how good a decision is, should we also factor in how good the resulting decision is based on that prediction? So not only are we looking at the value of the prediction or what went behind it, but the ultimate decision that is being made because of that prediction, and sort of factoring that into a regulatory framework as well. So these were just some of my thoughts. Also, generally, two smaller points were, are some factors even predictable at all? So, for example, criminal risk prediction. I think there have been many controversies on kind of whether people, sorry, I'm forgetting the word. Sorry, recidivism. That is the word I was looking for. Right? Whether it is in fact possible at all. And I think Arvind Narayanan and Sayesh Kapoor's new book, AI Snake Oil, really dives into why it is just simply we do not have the technology currently to predict recidivism. So should these legal frameworks also go into, hey, like while we can look at predictive decision making and certain factors, in some cases, there are some cases for which we simply do not possess the technical capability at this point to automate those decisions. And then by virtue of, should even humans be making those decisions at all? Um, so some broader questions that I leave with on predictive decision making more broadly. One, in which areas are predictions harder or easier to make? For very measurable phenomena, we might be able to make them easily. For social phenomena, especially social phenomena over time, that might not be so easy. Uh, how do we consider how good a prediction is in relation to what can be done using that prediction, right? Even a practically useful prediction can be morally dubious depending on what justification is given behind it or who is making that prediction. Even a factor that is also generally predictable across a data set might be difficult to determine in cases of, for example, life decisions or general future phenomena that might occur. And also, one thing in the paper that was mentioned, which I was very curious about, is that we should give a right for the decision maker to talk. A right might be the wrong word, but there should be an avenue for the decision maker to talk about, to justify when a more causal and thus predictive variable cannot be found. If for that decision, they should still be allowed to make that decision. So I was just wondering how that interacts with, for example, several predictive AI companies just openly make claims now that their predictions are accurate. But if we allow them to justify on this basis that we just couldn't find a more causal or predictive variable, what kind of doors does that open? And then how do we protect the decision subjects in that case? Finally, I will end just with 30 seconds of final thoughts. One is just considering the limits to prediction in a broader sense, that we do not have data sets available for some of these much larger predictions or much more consequential predictions to our lives. And there are also amplifications of very small initial advantages. And I think that's also accounted for in the paper, especially with these university admissions examples, right? How small advantages sort of catapult into much larger effects at the time of predictive decision making. Uh, and can we, coming back to an earlier point I made, can we bake in inherent unpredictability into our systems? Is that, in fact, a good regulatory route to go to protect people against the consequences of decision making in very consequential areas of their lives? And finally, I go back to an area that I'm always partial to, which is regulation by design, because it's what I look at. So, uh, can we consider regulation by design as a way to operationalize your framework, the ones that you talk about in the paper? Can we look at it, for example, through a privacy by design obligation, or through like an AI Act set of obligations on like Article 13, 14 obligations on design and deployment? So can we use those existing frameworks on design and methods like, for example, sandboxes, regulatory sandboxes? Can we use that to test out the value of predictive decision making and build in all of these factors that you've mentioned in the paper? So yes, I hope I didn't take too much time. With that, that's it from my end. Thank you so much for this.
No, thank you so much for that, Shreya. Professor Williams, would you like to respond to it before taking questions?
Yeah, thank you so much. I mean, what a fantastic, that's just like a whole, sort of smorgasbord of amazing sort of points to engage with about it. So thank you so much for that. Just going through some of the things that you talked about. I mean, I think we're completely aligned on humans are not great and humans are not the solution, and also that it's not automation that sort of raises these problems. I think we're absolutely completely in agreement on that. In terms of the shape of the framework and how do we operationalize it, and what sort of form does it take? That's a really interesting question. So I'm coming to all of this from my background as a public lawyer. And what I am increasingly finding myself arguing is that we do have a framework in public law that you could do this. So if you're talking about these decisions being made by public entities, we've already got a framework of tools of things like, the relevance rules and proportionality tools and reasonableness rules that we can use against public authorities. So it'd be quite easy to operationalize some of that stuff already just in the common law that we already have. For private entities, it would almost have sounded crazy to even suggest you could do this, 5-10 years ago. But because you're now seeing things like the AI Act happening and they do regulate private entities, it makes you feel like actually a kind of public law set of rules, but applied to very powerful private entities. Whereas you say you have that information asymmetry, you have that dominance and submissiveness that you have in a public context between state and citizen. If you have that in a private context as well, and you've got some forms of legislation saying, yeah, we can start to regulate this, then that feels like maybe some of our public law ideas might be able to flow into that sphere. I think probably they would need to be in the form of actual legislation. It's not impossible, and you do see the courts in cases like Braganza borrowing from public law in a private law context. So using a public law concept in a contractual interpretation private law case, it does happen. But I think it would be quite a brave court to go, right, I'm going to implement and legislate an entire framework in a private law case. That would be tricky. So I think probably it would have to take the form of regulation in a private law context, because there aren't the tools there already. But that could be done. And as I say, I think Article 5 of the AI Act is a start towards that. And you could just have more specific, more developed specific rules and regulations in doing that. I also really liked in that part of your comment, you talking about the difference between rights. And again, coming to this from public law, the UK public law approach is that it's public law is about public wrongs, not private rights, and it captures exactly that point, that you don't necessarily want to go down and this is sort of partly where I part company with Sandra as well, that I wouldn't go down the road of it being necessarily a right. Sometimes, like the right to individuation, maybe, but the general sort of right to accuracy, that seems to me is a public wrong of not aiming at accuracy, which is everybody's problem, not just the problem or the claim of a particular individual. And one of the problems with these systems is they can affect a lot of people at a small level rather than any one person a lot. And so, that makes a right framework problematic, but a public wrongs framework, I think, is much more appealing. So that I was grateful for that question, because I do think it's a public wrongs thing. And I think this framework is part of a much broader project that I'm working on, thinking about how we can use those public law tools even against private parties in this sort of public wrongs kind of way. Choices in the design of a system, and what's a good prediction, and some of the other things that you were talking about how do we know that it's a good prediction, and what are the limits to that. I, again, really appreciate those questions, because I think those partly go back to what I was talking about at the beginning about the target variable. And I think I'm just assuming that we've found a good thing that we can predict for. But one of the things I run our university admissions here, and that comes up a lot in quite a lot of the papers. So it's in Deborah Hellman's paper, and it's in various other people's, Neelan's paper. There's lots of papers where they refer to decision making for university entry as one of these examples, and you get very different views on what it is that we ought to be doing as a university. And we here are very clear that what we're doing is predicting for performance on course. So we constantly look at our recent cohort data to say, which factors for which people predict that they will do well on course or struggle when they get onto course. But that you get other people saying, oh, no, that's not what we should be doing. We should just be having quotas of, to make sure that we have a kind of diverse cohort, and, that they come from all over the country and all over the world and whatever. We need to have sort of quotas in place. So I think that very much those questions, we haven't ever asked them in the open, and saying, the process of saying, well, what's your target variable? What are you trying to predict for? Forces them into the open in a way that I think we've not had to address them before. So there's questions of, what are your choices that you're making in design of the system, and what is a good prediction? What are you trying to predict for, and is that a good thing? I think we now have to address those questions like we never have before, really. And I would say those all go into the sort of choice of target variable issue. Are some factors predictable at all? And the AI cycle, again, that's a complete assumption. I am assuming that you can predict. And again, university entry, we can see some things are more predictive than others. With that, again, I'm sort of thinking, well, again, and to your recidivism point, that is what human judges think they're doing. I completely share the skepticism of anybody being able to do this very accurately, but I'm sort of starting from the point of, if we're making human judges do it without data, we could probably improve on that with data, but we have got to improve on it. And you're absolutely right that, it seems odd to ask, when would you use a perfect system, when everybody's going, but we've never had a perfect system, and it seems really hard to build a perfect system, so why are you having that conversation? And I think that is very much a point that that we've done terrible versions of this so far. So I am assuming that you could do a good version of it, and there are a few examples where you can do good versions of it that I'm sort of hanging on to, but that is absolutely a question that we need to ask, really. And so I think, yes, we're sort of thinking, and you said, what is a good context for it? And I would say one way you can measure your ground truth is my kind of key one. If you're thinking about building for predicting accuracy, you want to set up where you can test whether you got it right or not. If I admit a whole load of people on the basis of their data and they actually do worse than in previous years, I know I've used my predictive data wrongly. Conversely, if we generally see the quality of candidates going up, and we're generally impressed every year, and we take broader groups of people, but we're also seeing stronger performance on course, I know my predictive accuracy is working pretty well. So it's got to be a context like that where you have that feedback. And another thing that I've written about separately is, I think decision makers ought to have a duty to check themselves. One of the problems is that if they have no incentive, and the market's not giving them an incentive to check whether they got it right, they can just go, oh, well, I might have made a whole bunch of decisions, but I don't care. I've got a bunch of employees, so it was unfair to some people. What do I care? And having a mechanism which says, no, that you need to check that, and you need to check that you made the most accurate decisions, and you need to adjust your system if you didn't, I think that is definitely something that we would want to incorporate as well. So yeah, I think the best use of these systems is in context where you can tell whether they got it right or not. And if you're trying to predict for a disease or predict for a risk or predict for, performance on course or something like that, you have got a measurable variable that you can then check yourself against. And that's where they're kind of most best being used, and where you can make the argument that, well, that is what humans are trying to do, and just doing it badly, so any improvement is an improvement. But yes, I mean, completely taking the point that so far they haven't been done very well at all. So yeah, amazingly brilliant. I've got a whole list of them written down, so thank you so much for those comments. That's really helpful.
Thank you so much. This is so insightful.
So Professor Williams, we have a couple of questions on chat as well. So the first question is that Apple so Rahul has a question. Rahul, I'll come back to you after the first one. So Apple have faced a lot of flack for discriminating against women customers, and the context that they've provided is that shortly after the Apple Card launched in 2019, it became the subject of gender discrimination complaints, where some applicants claimed men were receiving much higher credit limits than women despite having similar financial profiles. This triggered investigations. So the question is, how could we look at this issue given the current level of understanding and the proposed framework? I don't know, is that something within
yeah, absolutely. Yeah. So I mean, I think those are good examples of situations where there's, even if the system is predictively accurate, and who knows whether it actually is or not, but even if it is, one of the things you can do is constrain that by saying, yes, but you cannot make worse existing discrimination. So even if that makes your system more accurate, you just don't do it. Sorry. And I think that seems like a good example. Very often, actually, I don't think that is a choice. So very often it isn't that women are a less good employment risk or whatever. Very often, and this goes back to the target variable, the problem is, and you see this with employment systems which don't employ men, and that's because don't employ women rather, and that's because they've been trained and built on a system that predicts for what they've always done in the past. And that's what I mean about choosing your target variable well. If you build an employment system to say, find me the sorts of people who have worked at Amazon for years and become CEOs, yes, it's going to find you white men. If you build a system which says, find me the people who will actually be best at the job, find me the people who, the economic profitability of the company will go up over the next 5 years, it won't necessarily pick men, because you wouldn't expect that to all be men. So it's very much, some of these situations, what's happened is they've predicted for something which was itself biased. They've used data which was biased or proxy for biased data to choose it, and and the bias that was already in there in the data in the world that they were gathering. So it's sort of 3 different levels through the process they've incorporated bias into their system. This goes back to the point Stu was making about the designing the system. If you start off saying we're going to design for the target variable, which is really what we want, which is not just to replicate all of our past hiring decisions, it's to do better, and then we're going to think about how to choose factors which are going to predict for that thing we really want. And then we're going to make sure that the data coming in is sort of makes sense and is not itself biased to start off that process. Then you're going to have a much more robust series of stages to predicting the thing that you really want. And very often that's not what companies have done. And they sort of haven't put the effort into doing that. And some of that can be addressed through the discrimination rules if it is something like gender. But if it was, this is Sandra's point, if it was against, emo goth teenagers, then there isn't a system, because they're not a protected characteristic. So it's about sort of incentivizing that much better thinking through the process regardless, and say if you haven't got a discrimination complaint at the moment, you have no means of addressing that, whereas really you should. So
right, thank you. Professor, we have 3 more questions.
Yes,
and I know we are very short on time, so would it be okay if you took a couple of extra minutes? Is that all right?
Yes, that's fine. Yes, I can see the one about the right to individuation. I can I can do that one.
Okay. Yeah, so the question is, if right to individuation seems to be the way out, then where is the concerned individual placed in all of this? I ask this because a lot of times this exception case might themselves not know that are eligible to claim such exceptions, as is the deep informational asymmetry. So that's asked by Jayant.
Yeah, absolutely. And no, I completely agree with that. And I think I sort of say in the paper that it does to some extent put the burden on the individual, even if they do know that they're an edge case and they don't fit properly. It sort of puts the burden on them to bring that action. And I think that's right. And I think that is a challenge, although hard to see how you better that than nothing, I think, in some ways. in terms of the information asymmetry, again, there's a limit to what you can do with that. You might not know, for example, that you were sort of one of these smokers who was kind of genetically immune, but you can get somewhere on the information asymmetry, in the sense that that's where there's sort of a different part of, which is not in this paper, but talking about a right to explanation. And cases like Dun & Bradstreet Austria that have come out of the EU saying you have basically got to give somebody the gist of the reason. You've got to give them the key features that were used to that were relied on to make the decision in their particular case. And it, in some instances at least, it will be possible that if you look at those features and it says, these were the features that were used in your case, and you think, yeah, but that one doesn't really apply to me. I mean, yes, I am technically that, but I have all sorts of reasons why that's not really me. Then then you might have the information in those circumstances. And so to some extent the right to explanation can back that up and make it more apparent to an individual. But it is still true that they might not know that one of those features doesn't in fact apply to them, and it does, even if they do know both those things, it may be that that does put a burden on them to bring the action. I think that's more a question of how do we facilitate that happening? How do we enable individuals to be able to bring those actions as and when they do have them? But for sure, those are sort of practical hurdles. So it's not a perfect solution. It's just it's just better than not having a right to individuation, I think.
Right. I believe Rahul had a question. He had raised his hand. Rahul, would you like to? Although we're nearly out of time, but
sure.
Yeah.
I mean, I'll be very quick. And I don't know. Can you hear me, by the way?
Yeah, we can hear you. Yeah.
Yeah. So, I mean, fascinating presentation, Professor Williams. Actually, throughout your presentation, I was thinking, what is sort of the problem? What is the harm that we're talking about here? Because if we have informed consent, and if we have something like a misinformed kind of contextual regulation, then I didn't see the problem initially, and I thought your response to Shreya was interesting, where you talked about accuracy as the social wrong that we are targeting. And but I'm an empirical legal scholar, and I mean, I work on these questions with data all the time, and often, regardless of sort of the factors that and the data that we get, we often most of our studies are exploratory, right? And they're trying to find truth in really messy aggregate data. And so I was thinking, if accuracy is such a wrong, and then what do we do about exploration and science and the ability to predict? I understood your idea of humans as a ground truth, but humans are equally sort of fallible in that sense, right? And studies about human and the data that goes into making decisions is also fallible. So I think, wouldn't that restrict the ability of people to actually think about these questions and make progress on how to make predictions?
Yeah, thank you. So super question. And so first of all, yeah, completely agree with you that humans very much are fallible. I'm not a kind of an anti-algorithm person, because I think humans are perfect. I actually think really we've got to think about the standards to which we hold humans, and it's not right really to hold algorithms to higher standards than the ones we hold humans to. So I think that's absolutely right. In terms of the wrong in the world and where that leaves sort of exploratory empirical work, I think the key difference is whether you're making a decision on the basis of it. And in particular, like we talked about with the lifeguards, as opposed to sort of an individual decision, is it an aggregate level decision, or is it an individual decision that hits a particular person in a particular way? And I think exploratory, investigative work to see if you can find the cause of a disease, or to see if you can find the social factors. There's been a really interesting piece of work in the UK that shows that the more high streets are sort of closed down, and the areas that have the sort of worst performing high streets with fewest shops and most empty sort of lots, they're the places where you're seeing more far right political support for parties. So that kind of exploratory, or we found this thing that's really interesting, that's great, but nobody's making any decisions on the back of it. It's just informing policy generally. It might at some diffuse level go into a policy about, okay, so we need to put more investment into Britain's high streets, and that might be a thing that the parties who want to keep out the far right want to think about doing going forwards. But it's not going to sort of hit an individual in that sort of particular individual way. And so that's the key distinction, I think, that I would draw. Then if it is hitting an individual in a particular way, you said, oh, but if this person has consent, and I think that's the point that I think we are starting to depart from a little bit. that historically that's exactly what we've said. We've said, well, private law is private law, and if you've got an imbalance of power, well, that's the market for you, isn't it, fellas? That tough, get on with it. And I think what's really interesting is that because we now have this incredible imbalance of power and incredible information asymmetry that we've talked about a number of times between these sort of big entities and individuals, we didn't used to say that when it was the state and an individual. We didn't say, oh, well, that's just the state versus the individual for you. We said, no, we'll create a whole raft of public law rules to constrain the power of the state because it has this much bigger imbalance of power and this greater power that it can potentially abuse. And I think we're starting now to move away from the sort of market approach of, oh, well, it's free consent, saying it's not free consent. The GDPR says, in some circumstances, you can have an imbalance of power. That means there's no free consent because you've got no option but to consent. And that's not really good consent. So if you're not in that sort of world and you're not in the kind of free market, everybody's equal and we can all consent, and you're starting to say, well, there's actually that imbalance and it's starting to look quite like public law, that then I think gives you more right to constrain their accuracy of decision making in cases where it's going to hit a particular individual and have a particular set of individual impacts, rather than the sort of exploratory, what does this mean for diffuse policy issues going forwards, that kind of thing.
Right, thank you so much. Sorry, I don't think we have time for another question because it's we're already over the limit, but apologies to those whose questions could not be addressed. But thank you so much, Professor Williams, for joining us today. This was a fascinating presentation. And thank you so much to Shreya for joining us today and for her very, very insightful comments. And thanks to the audience members. It was thank you for tuning in, and thank you for listening and for asking your questions. See you next month in another round of our webinar series. And good evening or good afternoon, depending on which part of the world you're joining in from. Okay, thanks. Bye, everyone.
Thanks so much.
Thank you so much. Bye.
Bye.